We just
We're live.
Yeah.
All right. We're live with a smile. Ladies and gentlemen, schools, thank you for joining us. We are today going to be talking about quite a tricky topic, for schools. So I'm sitting with Brett from Bentley. And when it comes to school advisor side, what we really want to do is connect you schools with our best suppliers. And Bentley is 5-star rated on School Advisor, is an expert when it comes to debt collection, the legal side. And Brett has a lot of knowledge on a couple of key topics. So today we want to dive into Fish Hoek with that case and kind of just give you some tips and ideas as schools of what you need to know. So, Brett, thanks so much for being live with us.
Thanks, Peter. We can start chatting. Maybe we can just start off with just a brief explanation of the concept of school exemptions in public schools.
Yes, I think that would be good because I think there is a lot of confusion. So, if you could break it down for us.
Right. Okay. The idea is that public school fees are statutory liability in terms of the Schools Act, but they've passed the regulations to try to give parents that are on fee-paying schools that are unable to pay school fees an option in which they can be exempted from paying school fees. There's basically three sort of types of exemption that you get. The standard exemption can be full or partial, and it's based on the person's income. And then you get conditional, which we'll come back to, and automatic, which is certain categories of person, for example, foster home, orphan, and that type of thing. So, but the biggest confusion is now surrounds conditional exemptions.
Okay, so what is a conditional exemption?
Okay, in the Fish Hoek High case, which was brought as more as a test case, one of the things that the court tried to deal with and tried to solve this whole issue of the exemption regulations not dealing with separated parents. So in South Africa, you would think, okay, the average family is a nuclear family, but in fact, 65% of families are separate.
65%.
65%.
Okay. So this is something major for schools that are realistically 65% of their parents could be applying for this kind of exemption.
Yes. So it's a major area, and it was a major area that wasn't contemplated in terms of the school regulation. So you had this situation where parents are separated, they're alienated from each other. You've got one parent coming to the school saying, I want to apply for an exemption. Here's my income. Please work it out. And the school was saying, well, no, we need both parents. And that's where the problem lay, was dealing with these separated parents and how to be fair between both the school's rights and the rights of the separated parent.
Okay. So this is what happened at Fish Hoek, obviously. Can you just run through the kind of the pre-bit to it and how it actually ended up at the High Court?
Yeah, it started off with a dispute between the school where Mrs. S, as she's referred to in the court papers, came to the school, said, I'm a divorced mother. Here is my income. This is the maintenance I'm receiving. I'm in no contact with the father of the child. This is all I'm prepared to give you. The school, for its side, refused the exemption on that basis. And a 2 or 3 year dispute ensued, where eventually Mrs. S ended up with a NGO by the name of Equal Education, and they brought a declaratory to court to resolve this whole issue of how you deal with separated parents and exemptions.
Okay. So I know it was a massive judgment case. It sets a precedent for every other school. What was the judgment? What was decided upon?
Okay. So this is where the court tried to be creative, for want of a better word. One doesn't think of courts being creative, but it tried to be creative and look for a legal solution, because it went to the High Court, and the High Court said, here in the Western Cape, said that parents are jointly liable, and that caused many problems. So it ended up in the Supreme Court of Appeal. And the Supreme Court of Appeal looked at this whole concept of conditional exemption. Conditional is where it's given on condition that if financial circumstances change, the school can go back to the parents. So what it said in the case was that both parents are jointly and severally liable for the school fees. So not just 50-50. One parent can pay 100% of the school fees and then have to look to the other parent to recover those funds. That's the whole concept of joint and several liability. It went further than that and said, okay, let's try solve this thing by using conditional exemptions. We will say that if, for example, one parent comes to the school and says, here's my income, I've tried to contact my ex-spouse, the parent, or the other parent of the child, they won't cooperate, then that parent can deal with the exemption purely based on their income versus the school fees, as opposed to both parents' income.
Okay. So we've actually just had a question come in. So what would the party who comes in, obviously they're giving proof of their own income. What proof do they then need to give that there's been a divorce or separation, that they have no contact?
Okay. None of the other provinces or the case gave clarity on what level of proof would be required. But fortunately, the Western Cape Education Department has put out a directive. And in terms of their directive, they say that, for example, if there's a protection order between the parents, then in that case, the protection order is all the proof that is necessary. Because obviously they've reached a state of alienation where you wouldn't want them to attempt communication there. If that parent has, the cooperative parent, for want of a better expression, has tried to go to the other parent and they just not complying, then they have to show proof that they've perhaps written an email to them, communicated with them in some way, or even go as far, if it was verbal, put up an affidavit. If the parent, as in some cases, there's no contact, they don't know where their parent is, again, an affidavit showing that stating that they've got no contact.
So if we had to take the case of Fish Hoek, now that there's been this whole process, Mrs. S arrives at the school.
Yes.
What is expected of the school? What is expected of Mrs. S? Can you make this quite practical? So literally, what does the school need to ask? What information do they need to get?
Okay. Firstly, the first thing that the school should be doing is they should be making sure that for separated parents, that they're not expecting separated parents to disclose their financials on the same document. So when parents are alienated, they don't want each other to know the ins and outs of their financial affairs. So there should be two forms, one for the one parent and one for the other parent. They shouldn't expect them to complete it on a single document there. So that's the first thing that they should be doing. If there is a situation where the parent that is applying for the exemption says, I've made all these efforts, I've tried to get hold of them, and they give this evidence that we've just previously discussed, then the school can take the step of trying to contact that parent themselves, the non-cooperative parent,
Yes.
and write to them and try and make contact. The case then goes on to say, if they can't get that practical or they can't get that person to cooperate, they then must grant that person a conditional exemption based on purely their income versus the school fees and use the normal formula as though that the non-cooperative parent were not alive, for want of a better expression. So then they calculate it based on that.
Okay. So obviously for schools, if you've got, and we know at the moment within the economy in South Africa, schools really need their school fees. So if they are not getting this income in, they're pretty much losing this income. I'm correct in saying that government is not topping this up for them.
Absolutely. And that's one of the things that a number of parents and organizations don't seem to take into account, is the fact that if any particular parent gets an exemption, it's not that the government comes in and pays the full amount of those school fees. The government will pay a few hundred rand at best on that. The rest of the body of parents, paying parents, actually has to cover that cost. So if you really if you drill down and you look at it really hard, it's actually a situation of the parents' rights versus the learners' rights, because the less fees that there are coming into school, the less quality education can actually be provided. So it's personal rights versus group rights, and sometimes that isn't taken into account.
Okay. So let's take into consideration Mrs. S comes, she gives her income statement, she gives proof.
Yes.
The school then can't follow up or somehow can't get hold of that parent. We just had a question that came and says, what happens if at a later stage, the exemption has been approved, it's all gone through, at a later stage, they manage to get hold of that uncooperative parent? What does that mean? Can they still claim school fees?
Okay, I'm just going to take a step back,
Yes.
and I'm just going to explain what they would do again, or what the court said they should do against the non-cooperative parent. They would send out, firstly, what is called a 41.5 notice to that non-cooperative parent. And then they can actually hand the non-cooperative parent over for legal collections if he
Okay.
doesn't comply.
Right.
If then, for example, in the legal process, summons is issued and all of a sudden he becomes cooperative,
Okay.
and he comes in and his income is given, it's unclear. The case is unclear, because what the case is saying is that if a conditional exemption is given, you should do a letter to the cooperative parent saying, we've given you a conditional exemption, we've worked it out in accordance with your salary alone, but if your income changes, then we will relook at it. I feel the court should have gone one step further and actually said that if it's later ascertained what that other parent's income is, we will recalculate it based on both parents. That's what I believe that schools should be doing, because that's the only fair and logical way that you treat cooperative and non-cooperative parents and look after the school's rights at the same time.
Okay. So let's run through that just to practically help the schools.
Okay.
How can they set that up in such a way that legally they can still claim from that parent? Is there stuff that they need to do on their side? What is the kind of the legal steps to give them the biggest chance of actually claiming
Okay.
from the uncooperative parent?
I think what they need to set up is maybe chat to some expert to put together a letter to parents that qualify for conditional exemptions, setting out the grounds of the condition, so that they keep the door open in the future, that if they do manage to get the uncooperative parents' income, they can recalculate the exemption at that stage.
Okay. And is that something that you can just, that letter, say you wrote it for the school,
Yes.
is that something that the parent would need to sign, or is it something that you just need to prove that you've given to them?
I think you just need to prove that you've actually sent it to them.
Okay.
Yeah.
And is that something that would need to be written by a professional like yourself,
I
or is it something a school could?
I would highly recommend that it be written by a professional, because there's a lot of legal consequences of it, and I would have it professionally drafted.
And then just run through the legal process. Say a school, Mrs. S comes, they do all the paperwork, they give her an exemption. You then mentioned the writing of the letter for the other parent.
Yes.
What are those steps? At what point should a school look to hand over it to a debt collection company like yourself? What should they do themselves? What should they hand over? What's the biggest, I suppose, what's the most likely way the school is
Yes.
actually going to get that extra income?
Yes. Look, once they've done that 41.5 letter, the Schools Act says that there's actually a 3-month period before you can take action against that non-cooperative parent. So after that time period is expired, they should really be handing over and to the debt collector or to the attorneys, whatever the case may be, and then looking to enforce against that parent there. In terms of documentation, I think the legal requirements, if they could just, you're looking at things in terms of handover, general handover, you're looking at admission documents, copies of admission documents, copies if you've done a 41.5 letter, and if you've done that conditional letter to the other parent. I think those are, in terms of your documentation, is more than sufficient. And then the particular year's fees to which it relates, the details of the learner, and the amount outstanding. I think that's pretty much covers.
Okay, then another quite practical question. How far can schools go back? Because I'm saying there's a legal opportunity now for schools to go to uncooperative parents and kind of claim from them. How far back? Can you go 5 years, 10 years, 1 year?
Yeah. Look, the situation with schools is that school fees are not a tax, therefore there's laws of prescription. Taxes can last 30 years.
Okay.
Obviously, Mr. Taxman likes to look after himself there.
Yeah, he protects himself.
Yes, yeah. But when it comes to school fees, although it's a statutory duty, it only lasts 3 years.
Oh, wow.
That the school fees last, unless there's been an interruption of the prescription payment, or by some sort of acknowledgement. It could be something as simple as the parent writing and saying, I know I owe the debt, I'll pay next month. So that starts that 3-year process. So you can't go back further than the 3-year period.
3-year period. Okay. I think for us just to understand, obviously your company is an expert when it comes to this field.
Yes.
What are the benefits of actually having a professional like yourself on board versus the school trying to do it themselves?
Okay, look, there's a number of factors there. I think the important thing is with schools is that the school's laws and regulations become really complex. It's not simple anymore for schools. In some ways, I sometimes tease my schools and say they've got more difficult than the people involved in commerce and the consumers, because the laws that they have to comply with are really, really intricate. So if you're choosing to hand over, you must be handing over to somebody that understands the complexities of the Schools Act. That's important. The other aspect is obviously the enforcement side of things. You have to have somebody that's efficient, that deals with matters, that's on top of their matters, and that also perhaps has the legal clout to be able to, at last instance, enforce via taking action, summons, whatever the case may be.
Right. And are those full services that Bentley would offer? I know you top rated on School Advisor.
Yes.
Is that something that at what point would you get involved
Okay.
with the school? At what point would you recommend schools get involved with someone like yourself?
That is one of the benefits of using our company, is the fact that if you are one of our clients, we not only support you in terms of your bad debt recovery and legal debt recovery, but we also offer as a package, as part of the cost to our schools, free advice relating to school fee collections and exemptions. So we've got a team of 4 attorneys that are dealing with the school fees matters, that are willing to take your call and to help you with the process and to take you through the little minefields that might exist in terms of compliance, because obviously compliance is always an issue with knowing the exact details of what to do correctly.
Okay. And just on that, if a school doesn't do it exactly correctly, does that mean they lose the opportunity to get that income, or can they go back and correct?
Well, not only can they lose the opportunity to get that income, if we look at in the Fish Hoek case, the school was actually found to have been acted unlawfully and unconstitutionally, and was actually wrapped over the knuckles by the Supreme Court of Appeal. So in that case, you can potentially draw a lot of negative publicity to your school for not doing things the right way.
So if I'm summing you up correctly, this is a bit of a minefield that's going to keep changing. Obviously, there's now been another case with Fish Hoek, and generally, though, a school is going to need a professional. There's no way to expect that the BERS or business managers can be able to keep up with this law themselves.
Absolutely. It really is. It's changing year by year. There's new developments that are happening. So, yeah, there's the other aspect is training, and that's also something that we offer as well, is to try to keep the school staff as up to date in the law. And we offer annual seminars, Cape Town, Joburg, Durban, keeping people up to date in terms of what is happening in the law.
And if any of our clients would like to find out, any of our schools want to find out a bit more about you, what's the best way to connect with you?
They're more than welcome to contact either myself or Sue Walker, who heads up our sales. Give us a shout. Our website is pretty simple. It's creditcontrol.coza, and they can find our details there.
Okay. And then I'm going to cede one last thought. For the Fish Hoek case, is there any parting thought, something that you think is key that we haven't chatted about that schools should be aware of? Any last wisdom? And while you're thinking, I'll give you 2 seconds to think. Also, I'd recommend to the schools, if you want to get a good feel of Bentley, just pop onto School Advisor and check their reviews. It's very unusual for us to find a company with so many 5-star rated reviews, and we know those are all real schools. We've checked them. So yeah, parting thoughts, anything you think the school should know?
I would just like to say to the schools, when you're dealing with any particular parent in any situation, deal with that parent in the fairest possible way that you can deal. Imagine yourself in the future being a school that is put in front of a court, and the details of how you've dealt with that parent are brought in front of that court. I'd say follow the law and be as fair as possible.
Okay, that's brilliant. I think that's a fair point, but it's going to make me ask one last question. How, as a school, obviously, I think schools by nature are trying to look after the parents and the pupils. How do you be fair, but at the same time don't get pushed over?
Absolutely. Well, that's the thing. You have to, schools have to stand up for their rights. And because of the way that the exemption system is set up, it almost pits schools against non-paying parents, which is unfortunate. You know, it would be a different case that if, when exemptions were granted, the government paid the full amount of the exemption, but that's not going to happen in our current education system. So yes, schools have to find that sweet ground between being passive and being aggressive, and maybe find the assertive as the home field.
I don't know. My view is I think outsource it because it removes the emotion. Say, listen, we'll get Bentley's to contact you.
Yeah.
I think it is a viable option to protect the school. Is actually to be able to say, all right, well, we've got a third party that's going to help us with this, because it allows the school to remove the emotion.
Yeah. Look, we do certainly offer that. Certainly, some schools have got some fabulous people dealing with their internal collections. But there is another service that we do offer, is outsourced credit management that we can offer the schools as well.
Awesome. All right. Brett, thank you so much. We really appreciate your time. Thank you for everyone listening. Just a reminder, check out Bentley's on School Advisor. You can visit their websites. Next up, we have our next webinar is going to be in a couple of weeks, and we're going to be addressing the POPI Act. So protection of personal information. A lot of the schools out there are unaware that you are storing, well, I think everyone's aware, you're storing parents' and pupils' information. The law is going to be enacted, which means you're going to need to protect that information. So we're bringing in an expert to talk about that, so please watch out for that. We'll keep you updated. Once again, Brett, thank you so much.
Thank you for having me.
Thank you, everybody.
Cheerio. Bye-bye.
Bye.